Uh, Good afternoon, ladies and gentlemen. Good evening or good morning, wherever you are. Welcome to the third webinar of IDEA Vietnam Chamber. This is the third webinar on the most preferred arbitral institution in Vietnam. As you may know, that the first webinar is about how to learn international arbitration, and the second webinar is how to approach the international arbitration community, how to find the client. For this webinar, you assume that you already have a case and you have to find a way to deal with this case properly. So that is the purpose of our webinar, to invite the very experienced, well-known practitioner and the leader in the arbitration field to speak to you about the different arbitration process. Here today, we are very pleased to introduce to you Mr. Thi Kim and Mr. Hyun Lim of the KCAB International, Ms. Corinne Nguyen, experienced practitioner who will speak on the ICC arbitration process, Mr. Ngoc Minh, a partner of Dzung Associates, who will speak about the SIAC arbitration process, and finally, Ms. Thi Hang will speak about the VIC arbitration process. First of all, I would like to introduce about the two first speakers. Mr. Thi Kim. Mr. Thi Kim is the new Secretary General of KCB International. As an U.S. attorney, Ms. Kim has extensive experience in the field of international arbitration and served as the director of the International Center for Dispute Resolution (ICDR) of the American Arbitration Association (AAA) in New York. Before joining KCB as Secretary General, he worked at Samsung Corning Materials CBA Global, one of the largest intellectual property legal service provider based in the UK. He also served as a career consultant for one of the largest EU law firms. Mr. Kim was invited to speak in numerous conferences to speak about business management, technology, IP, and other issues in various countries, including China and Denmark. Mr. Kim graduated from University of California, San Diego in 1994 and received his JD from St. John's University of School, New York in 1997. He's fluent in both English and Korean. Together with Mr. Thi Kim is Ms. Hyun Lim. Su is the attorney of Kim and Chang, who specialize in international arbitration and cross-border litigation matters. Before joining Kim and Chang, Ms. Lim served as the first chief president of KCB International, where she was in charge of arbitration institution, international arbitration case management process, and an activity promoting as soon as the international arbitration hub. She has advised and represented clients in international dispute, leading role in over 45 international arbitration matters in different locations through Asia, Europe, and the US, under the rule of various arbitration institutions, including ICC, SIC, JCA, and KCB. In recognition of her contribution to the promotion of the Korean arbitration industry, Ms. Lim received the commendation from the Ministry of Justice in 2020. She also awards Outstanding Attorney Award by the Korean Bar Association in 2018. So please welcome Mr. Kim and Ms. Lim. The floor is yours.
Great, thank you very much. If you could give me 10 seconds, I will share my presentation. Good. Ladies and gentlemen, thank you very much. My name is Thi Kim. I am the current Secretary General of KCAB International. As I've been introduced, I actually come from the arbitration institution background. So it is my pleasure to be here to speak to you about, from a practitioner's perspective, in terms of how to handle KCAB international arbitration matter. And for that, I have asked Ms. Hyun Lim, the former Secretary General of KCAB International, currently partner and attorney at Kim & Chang, one of the largest law firms both here in Korea and Asia, in the dispute resolution practice team. And the reason why I've asked Ms. Lim to join us in this conversation was I thought it would be great for us to get a balanced point of view from both the very experienced institution perspective as well as someone who could actually provide practical guidelines when it comes to actually filing, handling, managing KCAB international arbitration matters, right? So I've actually put up a slide that gives us a slight, little bit of background about ourselves. And what I did was I put up a number of questions from each stage of the arbitral process and case management process as well. I'm not going to be asking all of these questions in front of you today. What I want to do is have you consider and have you actually review some of these questions and for Ms. Lim to provide from a practitioner's perspective, what you should consider, what you should prepare, what are the things from a practical point of view you should know and handle yourself and manage your client's expectation when it comes to filing stage, jurisdictional issues. What if you have a defective clause? Most importantly, arbitrator selection process, what should you consider? And after that, once the tribunal has been formed, then what? Then what happens, right? And not only that, how you should actually conduct yourself as counsel in front of both the client and in front of the tribunal as well. So I'm going to try to actually make this as practical as possible. So I'd like to actually welcome Ms. Lim to the floor. First of all, thank you very much for sparing your time from your busy schedule to join us.
Well, thank you. Thank you. It's an honor to be invited to take part of this panel. And I think this is a wonderful opportunity to not only talk about different institutions, but also provide a practical view of how to handle cases that have been filed in these arbitral institutions, including the KCAB International.
Okay. Great. Thank you very much. So let's get right into it. Your counsel, and you've been assigned a case to basically handle an arbitration case. Now it's with, you need to actually file it with KCAB International. Basically, from a practitioner's perspective, what information do you need to have, right? What should you put in there, right? Are there issues that you should be careful with, right? So if you could just explain that, that would be helpful.
Right. I think a great place to start is actually look into the international rules of the KCAB. And if you flip through the rules, you'll see that in Article 8, there's an entire section just on the request for arbitration. And while it's not exhaustive, it's not comprehensive, and doesn't really give you tips of what to include and what not to include, it gives you a checklist of these different items that should be inside a request for arbitration if you're looking for an arbitral proceeding that's effective, accurate, and I guess as speedy as possible. If I just list some of the very basic and somewhat obvious items, you should obviously include information of the parties, the contact information of the parties, the representative, if there are any, and of course, the bulk of the arbitral request for arbitration would be a description of the nature and circumstances of dispute that gives rise to the claims. One thing about what's really important in the request for arbitration is that you should try to frame the relief in a way that shows exactly what you are demanding. And from a secretary's point of view, and this is probably something that Steve, you probably know better, it's important to have a damage number out there, even if it's a provisional interim number that can be fixed, because that will allow the counsel of in the matter within the secretariat to process it through the administrative the process that need to be taken care of. Another thing that parties definitely should include are their opinions or their views on how the procedure should unfold. For example, the place and language of the arbitration. It's usually inside the arbitral provision in the contract that gave rise to the dispute. But it's surprising that a lot of parties simply forget to mention it. But it's useful just in order to get a quicker start into the arbitration to include the party's opinion of how many arbitrators, what language, what the applicable law is, and if there is a requirement to nominate an arbitrator, it definitely should try to name that arbitrator. And this is true not only for the claimant, but also for the respondent, if it's their obligation to name their party nomination. So yeah, I guess that's basically it. You usually have to specify the parties, the circumstances, the agreements, the relief, and then all the procedural elements that you would want the Secretariat to be aware of when they process this case.
Thank you. Just a quick question, as a follow-up question on the following stage. You and I have both seen a claim that have been filed with very, very specific and very lengthy explanation about what the case is, or complete opposite. You just have a few sentences, a couple of paragraphs about what the case is about and whatnot. How specific would you recommend the practitioner, when they file on behalf of their client, that the claim should be?
You mean the amount, or what the
the merits of the case?
The merits of the case.
Right.
So I think if you're a claimant and you want to process this arbitration process as quickly as possible, the best request for arbitration should be as similar as possible to a full statement of claim. So the quicker you draw out the issues, to explain it, and you have the documents that support it, the easier it is for the respondent to understand what the case is, to prepare their defense, and for the case to go on. I know there's some strategic reasons why the claimant, despite being the claimant, will not be ready to put in all that detail into the request of arbitration. Sometimes it's to see how the defendant comes out in response to the request, or sometimes the request for arbitration had to be filed by a certain point of time because of statute of limitation and whatnot, but the client just didn't give you enough information, or there has to be more investigation of what the facts of the case are in order to properly prepare the pleadings or submissions. So I think if circumstances allow, the more detailed you are and the more developed the case is, the better for you as a claimant. But if there are circumstances that disallow you to do that, then at least try to stick to the basic checklist points that I just mentioned, and which are listed out there in Article 8 of the KCAB rules.
Thank you. I think that's an important point. I think what Ms. Lim has alluded to is that obviously you want to be as specific as possible, but she also mentioned that sometimes for strategic reasons, you don't really lay out all of your cards on the table. Sometimes, and what I've seen in the past, is that you do file for arbitration, but for the purposes of actually getting the other party back onto the either negotiation table, or they've been basically non-cooperative, recalcitrant, whatever that may be. So you take that one additional step in filing for arbitration to make sure that the other party is aware that your serious intention and whatnot. And I think that would be included in the strategic reasons, as Ms. Lim alluded to. So thank you very much for that. So let's actually then jump right into the second practical point here. You have an arbitration clause, so this is relatively straightforward. It says Korea Commercial Arbitration Board, but this is obviously an international case. It's a Korean party versus, let's say, a Malaysian party. Can you still file with KCAB International, or are you required to just file with KCAB? How would this work? Right.
Well, this is a point that I used to get a lot of questions from people around me while I'm still at KCAB, but you probably know the answer yourself, Skip, but KCAB International is under the same umbrella of KCAB. So even if the clause says arbitration and KCAB, but the parties have an international element, meaning one of the parties, one or both of the parties have their main office domiciled somewhere outside of Korea, or the seat of the arbitration is designated somewhere outside of Korea, then it has an international character, and therefore will be under the rules of the international rules of KCB. In terms of who administers these cases under the KCB international rules, because the KCB international was established as a separate division devoted only for international work, the council there, they are the people within KCB who are most knowledgeable about how these international rules work, and they have the most experience. So even if someone were to walk over to the original KCB and ask them to process the case, it will probably very likely be tossed straight back to KCB International. So just because I guess the summary is, just because it doesn't say KCB International, as long as dispute has an international element, it can be filed at KCB International. And even if it were to be filed at KCB, the domestic side, there will be some internal discussion so that the most appropriate and most the most experienced counsel will take over the case and manage it.
Okay, so now let's make it a little bit more interesting. So you now have a clause that says you know for sure that it was meant to be Korea Commercial Arbitration Board, KCAB, but it actually just says Korea Arbitration Board. It's missing, it's either misspelled or there's a simple element that's actually missing. How would you actually then handle that?
It's actually something that courts around the world have dealt with. I remember one distinctly where the arbitral clause referred to KCB, or it was clear that the parties were referring to KCB, but instead the clause was naming it as the Korean International Economic Committee, which is very similar to the Chinese CTAC, but just that the word C, the capital C, was changed with the capital K. So the respondent actually responded to the request for arbitration. They appeared for KCB. They just ran the whole case as if it was a KCB case. But later, when the award came favorably to the claimant to try to enforce it in a Chinese court, the respondent actually tried to raise the objection that the KTAC was not KCB, and therefore there was a jurisdictional issue out there. But the court in that case said it was just clear because KCB being the sole arbitral institution in Korea, and the conduct of parties that ensued after the request of arbitration was filed makes it clear that both parties were thinking of KCB, but it was simply misspelled in the clause. So I think just the fact that the clause misspells KCB or designates it in a way that's ambiguous, there still can be jurisdiction if you look at the circumstances, the party's intention, and also the fact that KCB is a sole and only recognized arbitral institution in Korea. That all these elements, they comprehensively point to the fact that cases or arbitral clauses that have a slight misspelling of KCB will still provide KCB with the jurisdiction to oversee the case.
Thank you very much. And now, as this isn't, as you mentioned, this what seems to be a relatively straightforward jurisdiction and clause issue could later become a more of an enforcement issue, enforcement challenge. You know, a respondent or the other party who remains quiet throughout the process, all of a sudden, once they get the award, they challenge it by saying they didn't have jurisdiction or the institution, you know, was defective, whatever that may be. So there's a follow-up question to that is, you may now actually have seen a clause that says multiple institutions. So what if it says the dispute shall be under the law, under the rules of the KCAB and or VIAC or ICC or something else, right? How have you handled something like that in the past?
So as counsel, it would depend on whether I want to go to KCB or the other arbitral institution. But I suppose the neutral answer for that is it all depends on how the the tribunal sees the case. So the interpretation of a jurisdictional issue due to ambiguities in the arbitration clause is something that a arbitral tribunal has to review and decide. This is, I think, what's called the self-determination power of the arbitral tribunal. But from a practical point of view, before we even get to the stage where the arbitral tribunal looks into this clause, something must happen in the beginning in order to get that arbitration tribunals up and running. Typically, from very practical view, if I were counsel and if I wanted this case to be lodged in KCB, I would try to contact the secretary of KCB, say that please lodge this as a case. I will pay up for the initial part of the cost to get it running, and then get the tribunal to decide whether this clause is a valid clause in favor of KCB's jurisdiction. And probably the case, if it was, probably that would be the same case if I was a counsel and wanted that case to be filed in VIAC. So yeah, it's no clear answer, but I think there is a practical route of how you solve issues like that.
I think that's very important. What Ms. Lim has just mentioned is that, as I mentioned, this is actually from a practitioner's point of view and to provide guidelines to who are listening to this webinar, who are either already in the industry or is about to actually get in the industry as well. So U.S. counsel have a choice. You have a strategic reason to either go with KCAB or maybe even non-KCAB institution for whatever reason that may be. And the second thing is, yes, it is up to the tribunal to actually determine the jurisdiction of the matter. But if you are going to actually proceed, then proceed quickly and follow all the procedures so that you could actually get that tribunal information as quickly as possible to get that determination so that it doesn't take a ton of time for you and for your client just to have it determined that, oh, you should have actually filed with somebody else, right? It's a good point. Thank you very much. Okay, so now let's get into one more administrative issue and something that we all have seen before when we're actually handling a matter. You have the other party, the address that they have or the contact point that they provided before this whole arbitration came along, it worked fine and whatnot, and all of a sudden they're no longer reachable, right? For whatever reason. How have you handled that in the past, Ms. Lim, may I ask?
Well, luckily as counsel, most of the cases didn't involve the case of a missing respondent or the respondent that has, been out of reach, because the disputes I've seen generally typically involve major companies and they don't evaporate over the night. But I do remember overseeing cases at the KCB where me and the counsel team had spent quite a lot of time trying to contact the claimant and to ask them to reconfirm the address or take other means to find the address of the accounts of the respondent in order to make sure the service of process is correct. And the reason why so much time and effort was devoted to ensuring that we had a workable respondent address is basically because of the legal requirement that service of process must be proper in order not to get challenged during the enforcement stage. So this is also a issue that I think the tribunal will have to get involved and to get and provide their views. But if you're a claimant and you think that getting an award, even if it's a default award or an award under the absence of the respondent, and have a enforceable document, not enforceable, but a conclusion about this legal issue, then as long as you assume the risk and to go forward, the fact that the respondent's address doesn't work isn't in itself a reason to desist arbitration. But the risk that the respondent will later come back and complain to the enforcement court that they did not get proper service, that might come back and haunt you as a claimant. So I think it's a matter of deciding what your strategic goal is for initiating this arbitration, and whether you would want to go forward despite all that risk.
Great point. From the institutional perspective, at some point, if we have a respondent who is not responding, or whatever address continues to bounce back, we'll keep all of that in the record, in the file. We'll keep it in the record in terms of how many times we've tried, how many different methods that we've tried to properly contact respondent, properly serve respondent, and then the participating party could take that along with the award to demonstrate the effort that you've actually undertaken to actually proceed with the arbitration process as appropriately as possible under the rules, right? Thank you very much. Okay, so now,
if I may,
yes,
if I just may remind you that in Article 4, subparagraph 2 of the KCAB International Rules, sometimes parties may have to, or claimants may simply have to rely on the last known address of the party. And like you said, keep a trail of that all attempts were made in order to contact the claimant through that address. And the notification should be made by delivery against receipt, registered post, courier, and whatever leaves a record of dispatch. So there is an article related to that.
Okay, perfect. Spoken like a true former Secretary General of KCAB International. Thank you very much. Now let's get into the arbitrary selection. This is where we typically get the most amount of questions. This is where typically the clients ask the most amount of questions to the counsel. Do you know this person? Have you worked with this person before? What are my chances of winning this case under this arbitrator? Whatever all of that may be. So keep in mind the questions that I've listed there, but I'm just going to ask a relatively more general questions to Ms. Lim. When you are selecting an arbitrator on behalf of your client, what are the factors that you typically consider in looking at the arbitrator?
I think the 2 points come immediately to mind. One is reputation as a reliable and credible arbitrator, and 2, availability meaning the dedication that the arbitrator, prospective arbitrator, may put in that particular case. It's very important not just to have an arbitrator that advocates you as if she or he is an advocate for you. That might actually backfire because it only undermines the reliability or the neutrality or the perception of neutrality of the arbitrator, because you can't go too far in trying to find an arbitrator that wins the case for you as if it's she or he is a liar. I think the focus as a party on the long run that you should try to get from the arbitrator is someone who knows arbitration, what the arbitration process is, knows their stuff as in the substance, and is available to be responsive and to put your case in front of the calendar, as opposed to trying to push it back 2-3 years because of all the other different appointments that they already have.
I think that's a very important point. Reputation and availability, and these are the 2 things that from KCAB as an institution looks at as well. In particular, we look at availability. Not from just when are you available to handle this, but are you actually available to devote the time necessary to sit as an arbitrator on this one? Because we have seen too many times where you have highly regarded arbitrator, but he or she is just super busy. Anytime you want to get a preliminary hearing scheduled, or even try to get an award, it takes months. If not, we've heard horror stories before. It takes years just to get something going on that, right? So Yeah, obviously look at from that perspective to make sure that we keep the spirit of the arbitration, which is cost-effective and expeditious method of resolving disputes. So I think it's a good point. The other good important point, which was made by Ms. Lim, which I completely agree with, is that this is a party appointment method, right? So KCAB default process is party appointment. So you actually get to choose your own arbitrator and submit that to KCAB. Having an arbitrator that understands your issues and your problems and your requirement, that's fine. But anyone who steps beyond that line and start to look like they are just there to support or basically advocate your case on behalf of you, then that actually creates, should we say, future risk for additional challenges. And anytime you have this appearance of impropriety, you have both the legal risk as well as a frowning eyes from the institution saying, wait a second, this is not exactly what we had in mind. So the number of things that you should consider, as Ms. Lim pointed out, as a practitioner when you are actually selecting an arbitrator. So good points as well. Thank you very much. Okay, now, so you now have this tribunal of highly reputable tribunal that's actually now formed. What's typically next? I've listed out a couple of things there, but anything else aside from what I've listed there that you have seen before, Ms. Lim?
Well, obviously the preliminary procedure conference or the case management conference, which is also another term we use often, that should take as early as possible. So if you have been appointed as an arbitrator, a good sign that we've picked the right arbitrator is that the arbitrator would proceed immediately to contact the parties to invite them to discuss among themselves, the parties, a provisional timetable that they may agree with, so that the council can block out their time and find their time, schedule conflicts, etc., ahead of time, and then try to put the parties together so they can narrow the issues or crystallize the issues that can be discussed and decided over the course of the arbitration. Another thing as counsel is trying to decide what procedural is proper for you. I know because there are parties from different legal traditions. One party would like to run this more similar to a common law litigation, whereas another party who might be coming from a civil law background might be a bit cautious about all these different common law style procedures and evidence taking efforts. So I think one thing that has to be decided once the tribunal is formed is to agree on a procedural timetable and a sequence of how the process will be set in a way that both parties can agree, maybe not totally satisfied, but still find a common ground where it's acceptable to both parties.
Okay, so now I'm going to make this a little bit more interesting as well. Again, is that you have, there are times where you have an arbitrator or arbitrator has made a disclosure during the appointment process that you're not comfortable with, or even after the preliminary conference call, you start to see, okay, I may not be comfortable with that particular arbitrator for whatever reason, whether it's performance issue that may be on that. How often have you challenged an arbitrator, may I ask?
If there are issues, I mean, from my perspective or from my practical advice is that if there are issues about a potential candidate arbitrator, that should be fleshed out and decided before the formal appointment. So once the formal appointment is there, the things get very complicated because you have to initiate a formal challenge procedure, which requires a formal decision that's written down. it's just very complicated. And of course, because it's such a small tight-knit community, it creates a lot of uncomfortable feelings among people who are involved. So if there are problems with conflicts or the suitability of an arbitrator, then it's best that the due diligence prior to the nomination should take place. And if, as in a secretariat, if you spot, at least when I was in the secretary, if we spot something that might cause discomfort in either one of the parties, we either try to be very conservative about confirming, or we simply reached out very openly to the parties and sought out their views. So anything, if the start of the arbitral proceeding includes something uncomfortable, if it feels like the wrong first button that's tied in the wrong way, then the entire process after that makes everybody uncomfortable. So yeah, any tribunal arbitral challenge issues should be addressed as early as possible, and if possible, before the appointment.
It's a good point. Basically, the point is, do this before the tribunal is formed, because once they are formed, then it'll be very difficult to actually, so we say, challenge or lodge a complaint on the tribunal. There is one other additional question that I'd like to ask. There is, this is more from a cultural observation, because me being a very U.S.-centric boy and whatnot. From Asian clients and Asian institution or the Asian clients' perspective, what I've seen is that a bit of a hesitation in submitting that challenge to about an arbitrator. Basically, there's this notion of how dare you challenge this highly reputable arbitrator, before the selection process, whatever that may be. I'm sure that you've actually operated across multiple different jurisdictions and advised multinational companies in general, but how have you handled something like that, that bridging that cultural gap?
Well, surprisingly, I don't think the Asian culture swept in too much in the arbitrator challenge situation. If there was a reason to challenge, I think parties were not shy about raising it. But I can see there's always a risk that parties may want to avoid that. If they challenge someone, but the challenge is not accepted by the secretariat or whatever competent body decides to challenge, then they're basically stuck with an arbitrator who might consider that party an uncomfortable party. So there's always a risk there, but I think it's more an issue of case strategy as opposed to culture. So I don't know how we're doing in time, but I think that's the answer I have for that question.
No. Great answer. Thank you very much. Okay, so now let's jump into the last portion, the hearings. And obviously now you've gone through a lot of the issues here. Well, we're now getting to the hearing stages, but obviously if you're dealing with the other party, in particular, whether they're from a common law jurisdiction, they're likely to request extensive discovery process or evidence request that may be. How have you handled a party that stubbornly and continuously requests very, very extensive and broad discovery, against your client?
Well, the basic difference between international arbitration and U.S. litigation is that the arbitrator can be very active in terms of cutting off all these requests. So I think if I were counsel, I would try to appeal to the arbitrary tribunal that this is going too far. This is just taking a lot of people's time and energy and doesn't really help in the outcome of the case. And as long as the arbitrator is experienced and is confident about her or his decisions, I've seen arbitrators step in and cut off the exorbitant requests on document production.
Okay, good. Ladies and gentlemen, I know I probably have another 100 questions I'd like to ask Ms. Lim, but we are running. Basically, I've already overstepped my time period here. I'd like to actually thank Ms. Lim for her very intuitive and insightful, practical guidance on this. My last comments would be that institutions, KCAB, whoever that may be participating in this webinar, we're here to actually provide services to the user. So don't be afraid to contact us to ask questions and basically, even if, as Ms. Lim said, if you have issues about arbitrator, if you have issues about delays, this is where you need to use the institution as the intermediary communicator to actually provide that, saying, where's the award? Where's the preliminary order? Why is it taking 90 days for this? All of that. We could actually assist you in that to make sure that this is a expeditious and cost-efficient process. Thank you very much for your time today. Ms. Lim, thank you again.
Thank you.
And I hope you found this helpful. Thank you.
Thank you. Thank you, everyone.
Tim and Ms. Lim, I'm sure that there's a few questions to you, but there also question can be also for Roy to other speakers. So I think we should leave it to the end of the webinar. Then we can discuss together. The next speaker will be Ms. Corinne Nguyen. Corinne Nguyen is of counsel of TKM Advocates. She is a French attorney based in Paris and has extensive experience in international commercial arbitration, IEC in particular. Before joining TKM Advocate Counsel, she worked at the ICC International Court of Arbitration and as a major US law firm in Paris. She has handled cases as counsel and co-counsel in numerous arbitration proceedings, including annulment proceedings before French courts. She has also served as admin secretary to Arbitration Tribunal. In addition, she's lecturer in international arbitration at the University of Paris, Nang, the La Fan, the University of Catholic, the Lille Paris campus, speak French, English, and Vietnamese. So Corinne Nguyen will speak about the ICC arbitration process. Corinne, the floor is yours.
Thank you, Dzung. So good morning or good afternoon to all of you from Paris, which is 9:47 in the morning. And before we start our discussion, I would simply say thank you to Dzung for this very kind invitation to join you to speak today about ICC arbitration process. But according to the suggested content of the webinar about the do's and don'ts do's. So I'm happy here to share with you my experience. And I will start with 3 points in my presentation, oral presentation, because I don't have PowerPoint presentation. So the first point will be focused on a brief introduction to ICC and its arbitral process. The second point, I will emphasize on 2 specific features of ICC arbitration compared to KCAB, for example, meaning the terms of reference under the ICC, and B, the scrutiny of the draft award by the ICC courts. And once we have done that, of course, I would share with you my opinion about some points on the do's and don'ts so that we can have a good discussion. And before we start talking about ICC arbitration process, of course, you have the ICC rules of arbitration, but I would suggest you also to consult some very useful documents, which is available under the ICC. That is the ICC note to the parties and arbitral tribunals on the conduct of the arbitration under the ICC rules dated January 2021. It's very useful to find idea confirmation besides the assistance of the Secretariat. And also the Appendix 4 of the ICC rules on the case management techniques, because the view for us practitioners is to go as quickly as possible and to reduce the cost of arbitration to the extent possible. That said, let's start with point 1 of my presentation, meaning the brief introduction to ICC and its arbitral process. I will start with just some statistic and some general information made available by the ICC. First of all, we have some preliminary statistic from the ICC for 2021. I guess that the final figures will be officially published this summer. And it appears that from an objective point of view, that the ICC remains one of, if not the preferred arbitral institution. Based on the facts, they said that the number of new cases they handle is 853 cases for 2021. And this figure is comparable to the one in 2020, even if it is a little bit lower. In 2020, the ICC handled 946 cases. So this is just an objective information. Most interesting for me is the amount in dispute. We used always to say the ICC is the Rolls Royce of arbitration. You need to have big cases. And surprisingly enough, the ICC has mentioned that the cases that they handle ranges from, in terms of amount in dispute, from $9,500 at the lowest until, of course, about $27 billion. So these figures show the ability of the ICC court to manage different categories of disputes, from the largest and most complex cases to maybe the smaller one. But the case will be handled in the same way. And this is very important. And they reflect the trust placed by the parties in the ICC court and its staff, services and role around the world. You should bear in mind now that the ICC is almost everywhere, offices around the world, in Paris, Hong Kong, Singapore, Sao Paulo, New York, and more recently, Abu Dhabi, for the settlement of the dispute. So it is very important, as Mr. Kim said, that you are able to get in touch with the Secretariat to get clarification, information, whatever. And I believe that this is a good point. That said, in terms of ICC arbitral process, we know now from what I read and from my understanding that the ICC can manage big and small case in terms of value and complexity. But beside that, I would say to the parties that arbitration, be it ICC, KCAB, or whatever institution is a private justice. And although it is based on the party autonomy, you must bear in mind, you must be ready to meet your financial obligation. Because, as we used to say, no money, no arbitration. And it's part of the do's and don'ts when you decide to introduce a request for arbitration before at least the ICC, and to meet your obligation under what we say the advance on costs. Why we need this amount of money, it seems very logic, but it simply allows the case to move forward until the rendering of the award. So if you want to move fast, be ready to pay. And to avoid also the administrative closing of the case for failure to meet your financial obligation by the ICC court. So when you go to arbitration before the ICC, bear in mind 3 minor points, but important. The filing fee is already $5,000, and it is not refundable for the claimant, which has decided to pay it. For big companies, this is not an issue, but for a startup, you know, $5,000 is a lot of money. But you must know it, and as counsel, I cannot help you in that. You must pay to the ICC. Then the second point, once you have introduced a request for arbitration, this is what we call the provisional advance on cost fixed by the Secretary General in accordance with the ICC rules. And this is fixed as soon as the ICC received the request for arbitration, and it must be paid by the claimant. Why? Because in the rationale, claimant has taken the initiative to do it. So at this early stage, claimant has to accept to pay it. So it is purported to cover the cost of the arbitration from the introduction to the terms of reference. We will come back to it later. Okay, so this is very important. And the third point is what we call the advance on cost fixed by the ICC court, Article 37.2. And usually it is fixed by the court as soon as possible, meaning, in my view, from the introduction of the request for arbitration until the receipt of the answer, including maybe the counterclaim. So here at this stage, the rules for the payment will slightly change because the advance on cost fixed by the court must be paid in principle in equal party, 50% by the claimant, 50% by the respondent. And whatever the claimant has paid so far will be deducted from its share of the advance on cost. And here, the advance on cost is purported to cover the cost of the arbitration until the end of the proceedings with the rendering of the final award. Knowing that, I would say that in my view, to summarize, there are three main steps in an ICC proceedings to make things easy. The first one for me is the request for arbitration, the answer and the counterclaim, and the constitutions of the arbitral tribunal. This is the first step, where the secretariat of the ICC has an active role, because they need to notify the request to the respondent, check the deadline, make sure that the parties appoint the arbitrator, or if not, it is going to be the court. So this is an active part of the secretariat. The second point would be, for me, the start of the proceedings with the transmissions of the case to the arbitral tribunal with the establishment of the terms of reference. Here in the second phase, you must bear in mind that the arbitral tribunal now comes into play. They are going to conduct the proceedings with the parties and with, of course, the assistance of the ICC Secretariat. So active role of the arbitral tribunal for the second phase, in my view. And the final one, the third one, is, of course, the award. Of course, you will not be surprised if I told you that you have the active role for the arbitral tribunal, which is called to draft the award, but also now the active role of the ICC court, which is called invited to scrutinize and to approve the draft award. We will come back to it because this is the key features. So this is a very short picture of the ICC process, but bearing in mind now, if you agree, let's stick to the two distinctive features of ICC arbitration, two distinctive and mandatory points that the parties must bear in mind. This is the terms of reference, as I told you, and the scrutiny by the ICC Court of Draft Award. The parties, even if they agree not to have it, cannot do it. And even if the arbitral tribunal agree not to have a terms of reference, they cannot do it. It will no longer be an ICC arbitration, and the case will be closed. Yeah, so now let's go on the terms of reference. As you may know, it is a unique and long-standing features of ICC arbitration, and it is governed by Article 23. And for me, this is the first task of the arbitral tribunal to draw up the terms of reference with the parties, which means as soon as possible when they receive the case from the Secretariat, bearing in mind that the Arbitral Tribunal should draft this document within 1 month from the receipt of the file from the Secretariat. But of course, this is an administrative deadline which is renewable by the ICC court. Why do we need it and why do we have this? Because it describes and fixes the parties' claims, meaning how it is done in the request for arbitration, and at this early stage, the answer. You have all the elements which should be included in the terms of reference in Article 23. But for me, there's one point which is important from the point of view of counsel and for the Arbitral Tribunal, is the list of issues to be decided. And it should be drafted at the beginning of the case. Why? Because for me, it gives a clear picture of the key issues, and it helps to streamline the process and get the parties' attention and the Arbitral Tribunal attention to what is important and to avoid difficulties. So if you are the counsel or even arbitrators, don't hesitate to spend some time on it. Don't leave, as I said, no stone unturned if possible, because it avoids later on the possibility for the parties to introduce late or new claims. Because if it falls outside the limits of the terms of reference, the Arbitral Tribunal can reject those claims. So it's good, you know, where I'm going, what are the claims? So for me, on a personal point of view and practitioners, I find this document very useful, and actually I like it. I like it for different reasons. As I told you, it is the first opportunity for the parties in the Arbitral Tribunal to meet. I like the face-to-face, in person or not nowadays is okay. You can handle via Zoom or conference call. This is not an issue. And this is an opportunity to meet, but also to confirm somehow the validity of the constitutions of the Arbitral Tribunal, and for the arbitrators to somehow to accept or to confirm that they accept the mandate to serve as arbitrator. So it's good to know where we're going. And also, if we move a little bit later, at the end of the day, when the court is invited to examine, to scrutinize and approve the draft award, it is a document where the court likes to see, oh, what are the list of issues? Do the arbitrator respect their mandate? You know, sometimes you are so excited about your case that you tackle issues that were not raised by the parties, or sometimes you forgot one issue. So you avoid the risk of infra or ultra petita, as we said. So I find it very useful. And if you avoid that, you avoid corrections of award or maybe additional awards. So this is good for me. So my personal recommendation is that the parties, whatever is your position, should and must participate in this process. Why? Because failure or refusal of a party to participate does not prevent the terms of reference from being drawn up by the Arbitral Tribunal, and I hope with a claimant. It does not invalidate the proceedings nor the possibility for the defaulting party to participate afterwards in the proceedings. And bear in mind that the terms of reference do not prejudge the case, okay? It only records the parties' claims and the Arbitral Tribunal missions. So by participating and signing the terms of reference, the parties do not in any way accept the party's claim, nor the jurisdiction of the Arbitral Tribunal if, for example, respondents object to the jurisdiction of the arbitral tribunal. So I would encourage the parties, especially the reluctant respondent, to participate for this reason. But sometimes you cannot convince your client as respondent to participate because they say, oh, if I sign it, it means that I accept it. And I do not. Okay, you do your best, and it is the job of the counsel. Mr. Kim and Ms. Lim has mentioned the case management conference, and I think that it is very useful. It is provided by Article 24, and it is mandatory. If you forget it as arbitrator, don't be afraid, the Secretariat will chase you because you must have the case management conference. When should you have it? I would say when you draw up the terms of reference or as soon as possible thereafter. Why? I think it's useful because you consult the parties on the procedural measures to be adopted and to be established afterwards in the timetable to follow. And how? Okay, either in person if you like it and you're not too far away, or telephone call or video conference, quite flexible. So once again, if I may suggest, if you are the arbitral tribunal, prepare simply a simple agenda for the case management conference for the parties' information and discussion, but this is left to the initiative of the arbitral tribunal. And to give you an idea, for example, in the agenda, you can say, okay, we are going to finalize or to sign the terms of reference, and let's discuss and adopt to the extent possible with the consent of the parties or decisions of the arbitral tribunal on the basic procedure rules of the arbitral tribunal. For example, how should the parties' communication take place? By email or to be confirmed by paper or not? I don't know, it's open. What is the format of document? Word format or something else? What are the systems to be used to identify the parties' exhibits? C for the claimant, C1, C2, and how about legal exhibit, CL? Okay, once we know, we stick to the rules and there's no misunderstanding. How the arbitral tribunal communicate? By email only? How witnesses can be examined, etc. And how about hearings? Should we take it in person or virtual hearing? Or should we stick the hearing must take place at the place of arbitration or not? Okay, this is a general discussion, but it is helpful. And the ICC for that has a checklist, for example, for a protocol on virtual hearing, but I believe that KCAB has the same to help the party. When you have the case management, all these seems to be easy and seems to be general recommendation, but bear in mind also another deadline for the arbitral tribunal, which means 6 months to make the award from the transmission of the case of terms of reference. So you see, this is very subtle, but bear this in mind and it's gonna help you. And also don't be afraid or frightened because you will always have the assistance of the ICC Secretariat behind you. They are here to help you as arbitrators, but as also the counsel. So that said, this is one key features of the ICC rules, the terms of reference. Now let's go to the second point, which is the scrutiny of the draft award by the ICC court, and it is Article 34. And when I say award, I mean partial, interim, final, including award by consent. The scrutiny by the court, so I told you, in practice is that you must bear in mind, you must know that all draft award must be submitted by the arbitral tribunal to the court for approval, and the draft has no effect vis-a-vis the parties before it is approved by the court. And it is, of course, not communicated to the parties. So I think it's helpful because when the arbitral tribunal submitted the draft to the court, meaning first of all to the counsel in charge of the file, he is already going to read it and the case maybe to seek some clarification. Okay, so if everything is fine, that's good. The counsel at the Secretariat will discuss this with the Secretary General. And if everything is fine and ready, they will submit the draft to the ICC court with the recommendation. But you must know that it is only recommendation and the court is the only body which approves the award. So it means that the court can follow the recommendation of the counsel or not at all. Okay, so the scrutiny will be focused on the form and the substance, but be careful with that. On the form, meaning that, okay, can we get more motivation? Or it seems that there is a clerical mistake. So usually that's nothing wrong with that and it's helpful. But on substance, the court only make a recommendation. The arbitral tribunal is the judge of the case. Don't forget that. Sometimes it's a tough game, you know, because you have some very respected arbitrator and they say, how can the court ask me to do that? But it's just to draw your attention. And the purpose of this is, for me, is very good because the scrutiny process is intended simply to enhance the quality and the enforceability of the award. And as you said, Ms. Lim, we have to think about the enforceability of the award at the end of the day because you pay for it. And I'm the first one to do that. And don't be frightened when you say this process is very administrative and it's very time consuming. For your information, when the court is called to do that, in practice, the court either meet in a committee session or at the plenary session. Committee session takes place once a week, one day a week with 2 sessions. And the plenary session for complex case where, for example, we have state as a party, usually we go to plenary session, it takes place 1 per month with a report from a member of the court. So you know, and now you understand why it is helpful to enhance the quality and to make the award acceptable for the losing party. If I lose, but I understand the reason behind, maybe my client will be willing to enforce it voluntarily. And this is the purpose of arbitration. Yeah. So, and under the ICC rules, but as far as the notifications of the award is made by the Secretariat to make sure that the party receive it, etc. Because the ICC also Secretariat is called sometimes to simply make certified copies of the award. So it's based on the original. So I don't have anything else to add, and I would finish, and I hope I'm not late. I don't think so. About the do's and don't do's with some maybe illustration what I can see recently. I would not make general recommendation, but because it depends on each case, and I don't know everything, but I would say if it is possible, and even if you are sure about your case, know your arbitral tribunal, meaning know the arbitrators, because as Mr. Kim and Ms. Lim say, you know, you have arbitrators from different cultures, so they have different approach, even if they work together. And recently, I have a recent experience, and as mentioned to you at the beginning of the case, the financial obligations of the parties. And as I told you, the advance on costs fixed by the ICC should be paid 50% by the claimant and 50% by the respondent. Nothing exciting about that, but it happens sometimes that the respondent refuse to pay its share for good or bad reason. I have no money, I'm not the right respondent. And I say, and sometimes it happens, I will pay if the arbitral tribunal decide that I am the right respondent. Okay, but as a matter of fact, I don't pay at this stage. So, as you may know, the claimant is invited by the Secretariat to substitute, to pay for the respondent's share of the advance on cost, so that the ICC court had the 100% of the advance on cost to cover the cost of arbitration, to pay the ICC and the arbitrators. And if the claimant wants to get the award, they have no choice than to substitute. And I can understand that sometimes there is a lot of money into it. But it happens in practice that the claimant, once it has paid for the respondent's share of the advance on cost, comes immediately to the arbitral tribunal with a request for reimbursement of the respondent's share on the basis of the breach of the arbitration agreement. So they take the view that since respondent has accepted the arbitration agreement, which is a contract, they breach it by failing to pay it. I can understand that, no problem with me, but this is one approach, the contractual approach. The other one is the administrative approach, meaning that this obligation actually is an obligation between the parties and the institution to manage the arbitration. If you don't pay according to the rules, claimant should pay. If not, the ICC will administratively close the file. So if you know your arbitrators, I have this case recently where the from Europe, and the council were very good, very professional, they know what they're doing, but they were a little bit overconfident, because for me, when I read it, they were pretty sure that to get the partial award, to get the reimbursement, okay? But unfortunately, among the members, including the chairman, the chairman is not in favor. And if you read carefully what he said, what he wrote, etc., you can have a feeling about that. Is it worth trying to do that? Or the question you raised, part of the do's and don'ts, should claimant make this financial obligation to get the final award as soon as possible? Because when you make this request, respondent will have an opportunity to respond, and the case may be you will have a hearing, and then the case may be the arbitral tribunal will need some time to draft the award, even if it seems easy. So there's no recommendation. You must feel it, but don't be overconfident, I would say. And if you can make it, do it, pay it, and go until the final award, because the positions of the respondent will be taken by the arbitral tribunal at the end of the day, when the arbitral tribunal, in my view, is called to decide on the allocation of the cost. So this is very important. But otherwise, I would say, as a party, I would say, don't annoy the arbitral tribunal. Meaning, if I can smile or make things a little bit more friendly, don't come unprepared, late, and aggressive. But it depends on the style, you know, I have nothing wrong. But if you are too aggressive during a hearing, for good or bad reason, I don't know, don't forget that the arbitral tribunal is here and they can call for a short break. Hey, oh, calm down, 5 minutes break, and then calm down, okay? And people will maybe listen to you better. And please don't send tons of emails to the arbitral tribunal. I think that Ms. Dzung has experience, you know, you have went tons of emails for good reason or bad reasons. You know, it is time consuming, and okay, you are sure that the arbitral tribunal will respond to your email, especially when maybe this is your first case. For experienced arbitrator, I have no problem, but okay, part of the game for the arbitral tribunal to educate also and to help young practitioners, no problem with that. But bear in mind that when the timetable is fixed, the parties must respect the deadlines which were initially agreed. And if you change it, you must come back for good reasons. You know, it happened because the respondent of the claimant decided suddenly to change the counsel. I don't know, it happened, you know, 1 week before the final hearing. Okay, the new counsel, even if he's the superstar, might be a little bit stressed, you know, so be careful. And I would also avoid dilatory tactics. We cannot avoid it. And Mr. Kim and Ms. Lim mentioned this, the challenge of the arbitral tribunal. And we can say, oh, maybe we are shy or we are, but I share your view, Ms. Lim, that taking the decision to challenge an arbitrator is not an easy decision, because you challenge, if you are successful, it's fine. You get rid of him or her. But if not, well, you have him or her in front of you. It doesn't mean that he's against you, but okay, you may feel a little bit uncomfortable. But if it is for good reason, no problem with that. Yeah. I don't know if you were aware to finish on that point. In a recent case, you know, last year, a party decided to challenge the arbitrator because he's old, 75 years old. He said he's old and it's time consuming. And at the end, okay, the president of the arbitral tribunal doesn't care, you know, he decided to withdraw because this is not part of arbitration and the philosophy for those who really practice it. You know, but part of the game, if I may say so. Also, I would simply say, be cooperative to the extent possible so that the case can move. And this is my last point to smile if I like to feel good. And this is for the arbitrators under the ICC. And I don't know what is the practice of KCAB and the other institution. As an arbitrator, your role, of course, is to conduct the proceeding as efficiently as possible with the purpose to render the award as soon as possible. As I said to you, within 6 months, if possible. Be careful, because when you submit late the draft award to the court, you may be sanctioned by the ICC court. It means that the ICC court can may reduce your fees at the end of the day. Delay can mean less pay. And from the practice of the court, the court can reduce from between 5% and up to 20%. And I can understand that, because it is simply unacceptable from the point of view of the parties to wait almost 1 year to get the award. This is not acceptable. This is not acceptable. So for those who are called to work as an arbitrator, just bear in mind. But the good arbitral tribunal for me is the one who is experienced, of course, but who is strong. You are flexible, but be strong when you need to be strong, and don't hesitate and to be frightened to take decision which might not please the parties. You are not here to please the parties, but you are here to make justice. But sometimes,
thank you, Corinne.
That's it.
Thank you, Corinne. Thank you very much for your presentation about the ICC arbitration process. Then we have to move to the next speaker. The next speaker is Mr. Ngoc Minh. Minh is a partner head of the HANA office and Inspiration Practice Group, also acting associate. Minh has presented client in international arbitration conducted under the rule of the ICC, SIC, and SKIC to resolve the cross-border dispute involving the immediate element. He has also acted in arbitration as the DIC and evaluation of enforcement proceeding before Vietnamese court. Minh is recognized as an up-and-coming dispute lawyer by Chamber 2020 and is praised as a very responsive, available lawyer who provides very practical and spot-on advice. Now Minh will talk to us about the SIAC experience. Minh, the floor is yours. Minh? Yeah, I can see your slide.
Could you hear me? Okay. So thank you very much, Dzung. And also my thanks to all of the participants and the attendees here today. So I'm Minh and I'm from Dzung Associates. I'm a partner for like nearly 10 years, and I'm very happy to be an arbitration lawyer. So the first question you all may ask is why I am here talking about SIAC. Obviously, I'm not speaking on behalf of the SIAC today, and the reason for me to be here today and talking about SIAC, the first thing is that I have some experience. I have been doing SIAC cases, VIAC cases, and ICC cases. And at the moment, I can share with you that I'm participating in like 5 SIAC cases. So the other thing I want to share with you as a reason for my presentations about SIAC arbitration today is that if you look at it from the perspective of the Vietnamese party, then you can see that Vietnam is becoming quite a player in SIAC. So here's the statistic of SIAC in 2021, and Vietnam has become the number 6 user with a number 55 cases and 43 as respondent, 12 as claimant. So Vietnamese parties are being sued in SIAC more than Vietnamese parties suing the other way around. And there are 6 appointments of Vietnamese lawyers as arbitrators, and 3 of the arbitrators are listed in the SIAC panel. So the reasons to talk about SIAC today is that you can all see that Vietnam is becoming a player in SIAC, and so we will have more and more exposure to SIAC as counsel, as parties, and as arbitrators. So it's good to know about the practice there. And today, I do not really want to go through the whole process because the other speakers, I agree with many of the points the other speakers already presented, and many of them are applicable to SIAC. Because I have experience in both SIAC and ICC arbitrations, and I can say that there are many similarities. Many of the things are quite compatible between the 2 institutions in terms of practice, but of course you can exclude the terms of reference. So the way I want to talk about SIAC today is that I will want to highlight a number. Firstly, I want to highlight a number of points in the rules, in the SIAC rules, that might not be common in domestic arbitration in Vietnam. And then I may want to draw up some of the practical tips. It's not just about SIAC arbitrations. It can be applicable in ICC arbitrations or in KCAB arbitrations or in any institutional arbitrations. And like Corinne already talked, we can look at the SIAC rules and also some of the SIAC practical notes to understand more about SIAC arbitrations. So if we look at the SIAC rules, then we can see that in many places in the rules, we can see the reference to the Court of Arbitration of the SIAC, the President of the SIAC, and the Registrar of the SIAC. The only point to note here is that these 3 bodies are not the bodies who will solve the case or who will decide the arbitrations. They are the administrative bodies of the SIC to administer the arbitrations and also to be in charge of the appointment of arbitrator process. And you may see that there's a similarity with ICC arbitration here in the sense that the role of the registrar, for example, is quite clear at the beginning of the proceedings. You will make a notice of arbitration, you will send a notice of arbitration to the registrar, and afterward, when you already have the tribunals, the tribunal will together with the party draw up the proceedings and then conduct the proceedings. So the only point to note here that you may see the reference to the court, to the president, or to the registrar in the rules, but their roles are unlike that of the tribunal. So now I want to move to the commencement of arbitration stage. In the commencement of the arbitration stage, is quite similar in other institutions. You have to file a notice of arbitration. That's the first thing. But what is different here that in SIC arbitrations, there are a number of special procedures or a number of special provisions about how that can help you to have to manage time and cost, or maybe to lead to a quicker resolution of the dispute. The first thing is that you may, in some circumstances, you may want to seek an emergency arbitrator, because in some cases you may need to get an interim relief, but the tribunal has not been constituted yet, or that you cannot really get to the national court to get the interim relief. So you may need to get an emergency arbitrator to get an interim relief, and that can be done concurrent with or following the filing of a notice of arbitrations. And when you get the full tribunal can come back and review the interim relief that is ordered by the emergency arbitrator. The other things you may not find common in domestic arbitrations in Vietnam is the situations of multiple contracts, joinder and consolidations, Multiple contracts here work quite different in the sense that first, if you have multiple contracts, you can file a notice of arbitrations in respect of each arbitration agreement together with a consolidation applications, meaning that you are commencing separate arbitrations for each of the contracts and each of the arbitration agreements, and you also seek to consolidate them at the same time. Or the other way around is that you can file a single notice of arbitrations covering all of the contracts and all of the arbitration agreements. But that notice of arbitration is also deemed to only commence separate arbitrations. And by filing the single notice of arbitrations, you are deemed to have seeking to have made a consolidation application. So there's no way to really commence a single arbitration covering all of the multiple contracts or all of the different arbitration agreements right in the beginning. You still have to go through the consolidation process. And the other things about joinder and consolidations. Joinder is when you want to seek to join a parties to the arbitrations. The parties may not be the claimant or the respondent, but maybe another parties who is bound with the arbitration agreement or who agree to be bound by the arbitrations. And consolidation is when you have multiple arbitrations and you seek to resolve them together in one single arbitration that is consolidated from the separate arbitrations. And here, I think the issue of joinder and consolidation can be very, very complicated. So to be quick, I will only want to note a point that the application for joinder or for consolidation can be decided by the court by the Siak court when the tribunal is not yet consolidated, is not yet constituted, or when the tribunal is available, it will decide the applications. And if you want to get the applications, the starting point that you will need a compatible arbitration agreement, or all parties agree to the joint or to the consolidations. The appointment of arbitrators is also very similar to the process in the ICC, in the sense that although the party has the right to nominate a candidate of its choice, it is not automatic. The candidate will not automatically become the arbitrators of nominated by the parties. The candidates still need to go through an appointment or approval process. And that appointment and approval process means that the candidate may not be approved or may not be confirmed. And as we already heard from other speakers, the points to note here that you may need to check very carefully about the availability of the arbitrator, or maybe about the signs of conflict of interest that may actually make him unconfirmable, or maybe in some cases, qualifications. Like, for example, when you want to appoint an arbitrator who may not be able to use the language of the arbitrations, there can still be a case in which the inability to use the language of arbitration may disqualify him. And then we may come to the issue about payment of the deposits of the arbitration fees. Here, I again want to echo what Corinne's already said about no money, no arbitrations. And this is very important, especially to the Vietnamese respondent, because in some cases, I've seen that Vietnamese respondent may not really want to bear the 50% shares of the payment of the deposits. And by doing so, the claimant, they may want to apply for a partial award on costs on the basis that the respondent has violated has breached the arbitration agreement or has breached the rules, and that the arbitrator can render a partial award on costs, forcing the respondent to pay his or her share of the deposit, and also the cost of the claimant who has applied for that partial award on costs. And that partial award on costs is actually a final award on the issues of the payment of deposits, and it can be enforced whenever the Vietnamese party has access, providing that the jurisdiction recognizes the enforceability of partial award. So move to the conduct of proceedings. The SIC rule is very clear in setting out quite a wide latitude for the tribunal to conduct the arbitrations. Rules 19 expressly states that the tribunal shall conduct the arbitration in such a manner that, as it considers appropriate, after consulting the parties to ensure fair, expeditious, economical, and final resolution of the dispute. And also, the SIC rules require the tribunal to hold primary meeting to discuss the procedures that will be most appropriate and efficient for the case. Usually, this will be a case management conference. And as with the case of ICC or KCAB arbitrations, the results, the conclusions of the first CMC will oftentimes be the procedure order, PO1, and the timetable. In the SIC rules, we also see that there's procedures for early dismissal of claim and defenses. And I think this is quite a novel thing if you look at the practice in Vietnam, because by applying for early dismissal claim and defenses, there may be a chance to simply do away with the manifestly meritless claim or with a claim that is so outside the jurisdiction of the tribunal that you do not really need to spend much time on it. However, to really prove that a claim is manifestly without merit or is manifestly outside the jurisdiction of the tribunal depends very much on the circumstance of the case. And sometimes the tests or the standards to prove may not be low or maybe very high to actually get a successful early dismissal of claim. Submissions of pleadings and statement stages. The usual case here, I think that is very much the standard practice, is that you need firstly a notice of arbitrations, then you need, then the respondent will come back with a reply to the notice of arbitrations. After you get the tribunal constituted, you will need to provide the statement of claims, and the respondent will need to submit the statement of defense. And after that, you may have rejoinders, or you may have further round of submissions. The thing to note here that in SIC arbitrations, from my experience, the practice is usually that all cards are on the table, meaning that all submissions refer to made by the parties shall be accompanied by copies of supporting documents. And this is written in the rules, in the SIC rule itself. And in many cases, you can also see that the tribunal, when issuing the PO1, the tribunal will also make more details, provide more details about the form of submissions or about the requirement for evidence, for expert witness, for legal authorities to be submitted together with the submissions. And in terms of time frame or in terms of time limit, if the claimant fails to timely submit a statement of claim, it is written very specifically in the rules that the arbitral proceedings may be terminated. And if the respondent fails to submit a statement of defense, or if any party fails to present its case in the manner directed by the tribunal may proceed with the arbitrations in the absence of the statement of defense or in the absence of the presentations of the case by the failing party. And I have a very recent experience in which the respondent tried to apply for an extension of time to submit the statement of defense, and the tribunal only granted a very short time extensions on the basis of a preemptory order, meaning that if the respondent still fail to meet that extended time limit, then the respondent will be barred from making any further submission, making its statement of defense. So again, I think here we should very much underline the importance of being aware of the time limit and follow it. And if you cannot really follow the time limit, you need very good reasons to apply to the tribunal for an extension of time. And in terms of evidence, the SIC rules, this is where I find very helpful. The SIC rules states very clearly that this tribunal shall determine the relevance, materiality, and admissibility of own evidence. And the tribunal is not required to apply the rules of evidence of any applicable law in making such determinations. I find it helpful because, like, if we look at the Vietnamese practice, in some cases or in some circumstances, you may still find the Vietnamese counsel trying to bring up rules of evidence in court practice in domestic arbitrations. And here, if we have that kind of clear rules in the institution's rules, then it will be very helpful to show that no, the tribunal has all of the power to determine the evidence. The final award stage, again, is very similar to the other institutions in the sense that the tribunal have to issue an award after having been satisfied that the parties have all the chances to make their case. And when the tribunal finds out, the tribunal will decide to close the proceedings. And closing the proceedings does not really mean that the proceedings is closed forever. The proceedings can still be reopened if the tribunal during its course of deliberations finds that there are issues that have not been properly presented or may need further explorations. And similar to ICC arbitrations, SIC arbitration also have a form of scrutiny of the award. And here it is done not by the court, but by the registrar. And similar to ICC arbitrations, the registrar can only suggest modifications as to forms or draw attention to points of substance. And the award have to be approved by the registrar as to form. However, unlike ICC arbitration, I think the scope of the scrutiny is not by the registrar might not be as extensive or as in detail like in the case of the ICC, because the ICC has the benefits of courts of many members from many different jurisdictions, while the registrar of the SIC and even the court itself, it's somewhat more limited in comparisons. So that is a quick walkthrough of the ICC rules. And now I would very much like to move to the practical points. The first thing is that know the rules, but here I think it's not just about knowing the rules. It has to be also knowing the environment. We have already gone through some quite notable features of the SIC rules, and now we may want to sit down and take a look at the environment, because SIC arbitrations, in my experience, can be rather common law influence. Usually, you will have Singapore as a seat, and you will have to apply the Singapore International Arbitration Act, and not just that, because Singapore is a common law country, you also have the case law of the Singapore Court on arbitrations. And here the Singapore Court, as I understand, has decided quite a number of important cases on issues such as the state of arbitration or law governing the arbitration agreement, or on the effective resolutions of disputes by arbitrations, and even during the pandemic on virtual hearings. So if you come into a SIC arbitrations, you need to know the rules and you need to be aware of the environment you are coming in. It may be very different from what you are used to, like in Vietnamese court practice, or like even in Vietnamese domestic arbitrations. The other points about the environment is that if you look at the background of the arbitrators by, I think, searching the reports of the SIC, you can see that many of them are from common law jurisdictions. Just sit down and take a look at the statistic about the geographical diversity of appointment. You can see that many are from Singapore, the UK, Australia. So that is one of the most important part of the environment. It is still very much influenced by the common law jurisdictions. And here the takeaway that you cannot simply wear the hat of a Vietnamese litigator or even a Vietnamese arbitration lawyer and walk in a SIAC arbitrations and expect to do things like you usually do. You need to put your head outside the door and and come in with a kind of like a fresh mind and be aware of all of the differences and then need to adapt to it. The other point I want to make is that you need to take the initiative. The simplest point that we always want to discuss or always want to send across when talking about arbitration is that you do not really want to treat the arbitrator like a judge, like a national court judge, in the sense that you expect him to do, do everything, to decide on his own initiative about your case, or maybe to direct you about the procedures on his own. No, you cannot really do that in SIC arbitration or in any international arbitration. From my experience, if you want the tribunal to decide to decide for you, the first thing you need to do is that you need to make submissions. You need to persuade the arbitrators, and that's about the merit. And if you're talking about the procedure, then the same thing applies. You have to take the initiative. You have to apply for what you think that is necessary for your case, and just look at the rule. Many parts of the rules have reference or have phrases like the tribunal need to discuss with the parties, or we need to consult with the parties. Here, it's not simply that the tribunal asks the parties. The usual practice is that the tribunal firstly will want to direct the parties to negotiate, to discuss between themselves, and then come back with the tribunal about the results of the negotiations. And the tribunal will only want to step in to decide if there are some matters that the parties cannot really resolve on themselves. Take for example, when we talk about discovery, document productions and discovery, usually the tribunal will let the party to exchange the request for documents between themselves, and only come back to the tribunal when there are deadlocks or when there are disputes about certain documents or certain categories of documents, and only at that point the tribunal will decide. The other thing is that you need to not trouble the tribunal too much, like Corinne already said. You may want to limit your communications between the two parties. And it's not like the tribunal will want to receive lots of emails about what the two parties discussing between each other or what they are negotiating about. And the following point that's flow naturally from taking the initiative is that you need to be ready to negotiate, because in many situations, in many cases, even about points of procedures or about points of logistics, the tribunal will firstly direct the party to sit down and talk with each other to work out solutions. It's not like you will have someone to make a decision for you right in the beginning. And be ready to negotiate means two things. The first thing that you need to be ready to persuade people. Here, it's not just about the tribunal, it's also about the other parties. And the other thing is that you need to be flexible. In some cases, you may need to compromise, or you may need to actually be persuaded by reasons. And be ready to not be aggressive. So to follow from that point, I would say that it is very important to be attentive and mindful of the situations. An example can be like this. In some situations when the parties are in deadlocks about the procedures, the tribunal will want to kind of like give a hint to the parties to resolve the deadlock. Maybe the hint may be quite subtle, like simple questions, but you need to be aware of it. You need to be mindful of it so that you can get what the tribunal wants and be flexible and resolve the issue without having to be too aggressive or to be too hard-headed with it. And the last point is about building the case and about evidence, because things like document productions or witness cross-examinations are not native to the Vietnamese legal system. And you need to be aware that when you come into the SIC arbitrations, there are any international arbitrations, there will be discovery, there will be document productions, and there will be cross-examinations of the witness if you want to use a witness. So you need to be prepared for that. And the best way is to prepare early, investigate by discussing with the clients, discussing with your clients, and try to find out who in their organizations best suited to help you with the case, to help you with learning about the details and the facts of the case. And then you take notes, you build up your case and prepare for cross-examinations or for witness cross-examinations or document production later on. And I think I would like to wrap up my presentations and maybe hand it back to Mr. Dzung to introduce Ms. Hang.
The next, the last speaker is Thi Hang. She is a senior counsel of VIC with 10-year working experience as a counsel at VIC 6 years. Hang is in charge of the arbitration cases with the international element. Currently, she leads the counsel team at VIC Hanoi and assists the Secretary General of VIC in innovating and completing internal rules and regulations for quality and nationality of the arbitration procedure at VIC. She is author of InFocus International Arbitration Skill events such as the annual webinar VIC Arbitration Series, the internal VIC Leaded Arbitral Seminar Series, and other. So Hang, we are quite late, at least half an hour. So work appreciate if you can move fast. Now the floor is yours. Thanks.
Thank you, Mr. Dzung, for your introduction. So I will be very, very quick. I'd like to share my presentation now. So good afternoon, all the attendees and the speakers. I'd like to give you a tour on arbitration procedure at Vietnam International Arbitration Center. So first of all, I'd like to invite the audience to look at the very brief graph of the history of arbitration in Vietnam. And you could see that the establishment of the IAC is in 1993, before any concrete laws on arbitration in Vietnam. So if you want to look to study about the development of arbitration in Vietnam, basically you just have to look at the development of Vietnam International Arbitration Center. And you could see that we are a very young jurisdiction. We have just about 10 years of operating under a law on arbitration, which is considered adopted some fundamental principle of the model law on arbitration. We are now preparing for the revision of the LCA. And we do hope that after, when we have the new law, Vietnam will be considered as a model law country by the Secretariat of the Arbitral. So this is the overview about the arbitration procedure at the IAC. You could see that we have, in principle, split the procedure into 6 stages, from the introduction of the request for arbitration to even before, after the award. And since we do not have much time, I'd like to just focus on some discrepancies in arbitration procedure at VIAC in comparison with foreign counterparts. I like to emphasize that the discrepancy might come from the mandatory regulation of the law on commercial arbitration in Vietnam, or from the VIAC assessment, adaptability to the current context of the Vietnam market on arbitration. So first of all, on the commencement stage, unlike SIAC, we have the request for arbitration and the statement of claims. At the IAC, we do not have that distinction. So basically, it means that the claimant has to prepare a quite detailed request for arbitration right at the beginning of the proceeding. And as Mr. Kim have mentioned, that we don't have to, claimant don't have to play on all the cards on the table at the same time. It depends on their statistics, but the thing is, if the claimant has to bear in mind that any amendments or supplements of the request for arbitration might cost some time of the proceedings, because the respondent do have the right, that's some time to respond for that new amendment or supplement. About the constitution of arbitration tribunal, the VIAC rule shares some very comments with other arbitration institution in the world, and in fact, we do not have the confirmation procedure as in ICC or in KCAB. So which means that the nominees by the parties most of the time will automatically be a member of the tribunal resolving the case. However, we do impose the disclosure obligation for the arbitrators, and that obligation will be throughout the proceeding, since they receive their appointment to the final works. And resulting from that obligation, there will be a separate procedure on challenging arbitrators under the rules of VIAC. And so after we have the constitution of the, after we have the arbitral tribunal, when at VIAC, the tribunal will normally have a very fast internal meeting between just the member of the tribunal in order to decide which procedural steps will be taken for the procedure. But that was in the past. I mean, when the case were not so big, and the capability and the awareness of the enterprises and the lawyer in Vietnam were not so good about arbitration. We have observed in recent 7 or 5 years, recently, that there's a dramatic development of the community of the lawyers practicing in arbitration in Vietnam, who are very well trained or have strong background on arbitration in Vietnam or abroad. So when they discharge their function as a counsel of the party at VIAC arbitrations, the international standards procedure is request and required. And in order to VIAC Secretariat have a very open approach to that development, and we very quickly adapt with that request demand from the market. And so in recent 5 years, you can see a lot of CMC or POs was conducted in arbitration proceeding at VIAC. And in fact, other procedural steps of an international arbitration proceeding, such as statement of factual witness, report of expert witness, or tribunal appointed expert, will actually happen in practice of arbitration at VIAC. And one more thing that about the adaptability of arbitration proceeding at BIAC is that when a foreign counsel consult the counsel of BIAC about which style that they should do in arbitration of BIAC, whether it is memorial style or pleading styles. We are very open for the suggestion from the parties, and the parties should raise their suggestions and working with the tribunal in order to agree on whatever they want, whatever style they feel fit with their cases. And in fact, the majorities of arbitration procedure at BIACs are follow the memorial styles. Move to the stage of a hearing. In the past, we do most of the time we do the face-to-face, physical hearing in Hanoi or Ho Chi Minh City. And in fact, we have we have about four premises around the countries that could provide the hearing facilities for the parties to join the physical hearing. And when the pandemic, when we hit the pandemic, the rise of the virtual hearings also was recognized at BIAC practice. We do have arbitration. We do have virtual hearings with remote with parties from different place, and arbitrators from all over the world, in Switzerland, in UK, in Singapore, and we also provide can manage smoothly remote transcription, remote simultaneous interpretation. So we understand that the demand for virtual hearings are somehow very that could be met at via practice. And again, I'd like to emphasize that all other steps that you could see in international international arbitration hearing, like cross-examination or hot tapping, could be conveniently conducted in a hearing at BIAC. And about the final arrest, when the tribunal consulted with the parties and the party confirmed that they have nothing else to submit or to present, the tribunal will close the proceeding and move to the deliberation and drafting award process. In fact, there's one very different features of arbitration in Vietnam is that there's no concept of partial award under the law of arbitration of Vietnam. So basically, we just have one award, which is final in one arbitration procedure in Vietnam, seated in Vietnam. So the time limit, the time for the tribunal to draft the award is a bit shorter than in Singapore under the SIAC rules, just 30 days. So as a case manager, the counsel at BIAC have to be very attentive to the process of drafting the award to ensure that the award could be, especially in the complex cases, could be rendered in time. And about the scrutinies of awards, I myself think that the scrutiny of award as the ICC Secretariat are doing now is so good. It have great effect in order to enhance the quality of the arbitration award. However, still we have to respect the career law of the proceeding, right? So under the LCA, there's no concept of scrutinies of the award. And the approach, the current approach of BIAC Secretariat is a bit similar with the approach of the SIAC registrar, that we do have some so-called unofficial scrutiny of the award. We do, have the step when the council will review the award in terms of form, and also we give some kind of recommendation for the tribunal in the matters of regarding the substantive matters of the award, and just for one purpose only, draw the attention of the tribunal about those matters and try to bring our best practice in VIAC or in Vietnam in general for the tribunal, so they can have well-informed judgment of that matters. So we are now trying to keep up with that approach, and we believe that will so much enhance the quality of the arbitral awards. And about the post-award stage, it's quite unique, I believe so. Apart from correction of the arbitral award or explanation of arbitral awards, when parties exercise their rights to invite the judicial review of the arbitral award in Vietnam, there is a significant support from VIAC itself and the tribunal to defend for the validity of the award if needed. That is also, again, is our commitment, the commitment from VIAC and the tribunal conducting arbitration at VIAC about what has been prescribed in ICC rules, that we have to make every effort in order to ensure the enforceability and, of course, the validity of the awards. So if you have some chance to look through the decision of the courts, of the Vietnamese courts, about in the outcome of that judicial review of the arbitral awards, you might somehow see some decision that refer to some letter from the VIAC or even the participant of the VIAC representative at the meeting, at the court meeting, in order to provide the court with information, with better information to defend for the validity of the award. And other matters in arbitration procedure, first about interim measure. Under the law of commercial arbitration in Vietnam, there's no emergency arbitrators. And in practice, VIAC has the experience, a very good practice of court support to arbitration in that matter. In 2014, 2015, or 2016, there's at least 30, decision to grant interim measure from the court in order to support for the arbitration at the VIAC when the arbitration institution is not yet constituted. So basically, we are now still observe a very good practice of the court support about that matter. About multi-party arbitration, after we have the resolution number 1 in 2014 by the Supreme Court, VIAC have made a revision of its rules of arbitration in order to incorporate the new regulation about multi-party arbitration, especially about the claims from multi-contracts and consolidation. But however, under the law of Vietnam, there's no concept of joinder yet. About the cost of arbitration, I saw questions from the audience about the cost of arbitration at VIAC. We do have the schedule of costs that public on our website, and there will be no other costs at VIAC arbitration except for those that public on our website. And it is the cost of arbitration is calculated on the lump sum basis. It's quite unique, I have to say. The advantage is that the party might, have a quite exact estimation about their costs in arbitration. But the downside of that, and we are aware of that, is that it somehow restrain the involvement of the senior arbitrators, international senior arbitrators in the world, in arbitration at BIAC due to the huge gap on remuneration. But still, we do believe that we still can, invite very well-known arbitrators to Vietnam and conduct arbitration. About the very important matter, of course, is the legal costs of the parties in arbitration. It is considered a very an advantage of arbitration over litigation in Vietnam, is that legal costs of the party could be recoverable under the rules of BIAC and the law on commerce arbitration. And however, the admissibility of the claims for legal costs of the parties is a bit different from international practice. So I do recommend the council and the parties consult with the secretariat before submit that. About the award, there's one thing I'd like to emphasize, that the award of the under the law of commerce arbitration is having the immediate validity as the court judgment in Vietnam without going through any procedure for recognition or enforcement. It is also an advantage of arbitration seated in Vietnam. But please be mindful of the definition of the domestic arbitration award and foreign arbitration award under the civil procedural code and the law on commercial arbitration, because it's a bit different from international practice. And about arbitrators, this is one thing I'd like to emphasize, that there's no limitation between non-listed arbitrators or foreign arbitrators when the parties want to select perfect arbitrators for their case of BIAC. And as I did mention previously, that we do impose the disclosure obligation for the arbitrators, and we do impose the international standards for independence and impartiality. We have made it public, the arbitrator statement by BIAC, the new version on our website, and you could see that the adoption of the well-known IBA guidelines for conflict of interest in our arbitrator statement. So I'd like to move to the second part about do's and don'ts very quickly. For party and council, as Ms. Corinne Nguyen and also Mr. Minh have just mentioned, you have to understand and you have to prepare for what will happen when you start everything up. So please try to get to know about arbitration at BIAC. We have made all the information about us available to our website, to our hotlines and our mailbox. Drop us some email, and our council will give you a detailed response. And we do have offices with available counsel can talk to you and answer to you to all of your queries in Ho Chi Minh City and Hanoi. And one more thing is that VIAC hosts a lot of events on the free of charge basis. Either physically or virtually. So in those events, we have VIAC counsel as a speaker, we have VIAC listed arbitrator as a speaker, and they will share a lot of insights of arbitration practice at VIEC. So please join those events, and you could send the questions for the speaker, and they will give you the information that you might need. And so when you understand about it, after you understand about it, you don't have to worry about anything at VIEC, and you have just file your case with your best. The VIEC secretariat, the council, always available around the clock, whichever time zone you are, and you can just drop an email, and we will be there. And about don'ts, I'd like to emphasize something that for the Vietnamese in council, please don't mix up between court litigation practice and arbitration practice at VIEC. Arbitration and court litigation are share so much in common, but still they are very different in nature. So for some Vietnamese lawyer who are very experienced in court litigation, you don't mix up the understanding, your understanding about litigation to arbitration. Please take some time and talk with our counsel. And for foreign lawyers, I understand that you have been practiced in so many other jurisdictions, and you may already arbitrated in so many prominent institution, but don't assume about identical procedure at VIEC and CF and ICC and KCAB, because the most essential elements of arbitration is adaptability. It has to be adapted to the local Korea law, as that is the law that regulates the arbitration. And so again, for the council, we are doing annual events. I mean, some kind of dialogue between VIAC and the council. Please follow the event, enjoy the event. At that event, VIAC will listen to all the feedback from the lawyers, from the council, and at the same time, the council can give us, any questions, and we will give you the information. For the arbitrators, as you could see in the slide, that is the first page of our arbitrator statements. So at the time of the arbitrator's appointment, this council or VIAC will send you an arbitrator statement. And together with that is the rules of VIAC, the code of ethics, the guidelines for arbitrators regarding arbitration at VIAC, the regulation on remuneration, the regulation on other types of, housekeeping matters. So please review it carefully, and in order to be sure that you are well understand about the way of procedure at VIAC and how we deal with all the administrative and housekeeping matters before you decide to accept the case, apart from other things, of course. And the second thing is that please consult with VIAC counsel at any time about any matters, either they procedural or administrative, or even about what is the best practice of VIAC or Vietnam about any substantive issues, because our counsel team as well trained, are lawyer by training in Vietnam. All of us are lawyers by training in Vietnam. We do have the information that might, helpful for you. So you just need to drop an email to us. And then again, please utilize all the internal guides and material from the Secretariat. We are trying our best to make it available. A lot of things to support the arbitrators, especially for non-listed and foreign arbitrators to conduct arbitration at VIAC. And about don'ts, there's one thing which is very different from our practice and international practice, is that at VIAC, the communication of I mean, the circulation of and communication has to be conducted through via secretariat. All the things have to do through via secretariat. So please do not direct communicate with the parties without an express agreement on that. Why is it matter? Because we have experience in our practice about the arbitral tribunal. They are very familiar with the international practice when the tribunal can directly communicate with the parties and just copy the secretariat. However, in Vietnam, the matter of service of notice are very different from other jurisdictions. And the secretariat is now in charge of ensuring the proper service of notice for all the arbitral documents in arbitration at the IAC. And there's one thing that I'd like to add about don'ts for arbitrators, as Ms. Corinne Nguyen and Ms. Su mentioned about challenging arbitrators. It's very common that it's now quite common at the IAC that the parties, when they see something from the tribunal, even not about the conflict of interest, but the behavior or the reaction of the tribunal, they might raise some kind of doubt on the impartiality or independence, and they lock their request for replacement. So for arbitrators, please keep your head cool when facing a party challenge. Just because in our practice, we do experience one circumstances when an arbitrator is being challenged, and the reaction is not so. I'm not sure. I do not have the assessment myself, but then based on the reaction of the tribunal of the arbitrators, the parties keep log in and another request to replace that arbitrator based on the self-evident tension and ill feelings, and that is not a very good practice to repeat. I believe so. So about the last part about the practice notes and guidance. The IAC is the most long-lasting international arbitration institution in Vietnam, but in comparison to the world, to the region and the world, we are still a very young arbitration institution, and we do have so many things to be done. We have several sources to get insights of the arbitration practice at the IAC, and I have put some links behind on the slides for the audience about our annual report, about our arbitration series, about our forms and our arbitration statement. And the codification is still in progress. We are now dealing with the new version of the guidelines for arbitrators regarding arbitration at the IAC, which is trying to adopt all the best practice from international arbitration. But it's of course subject to, but still we have to subject it to the mandatory regulation of the law on commercial arbitration. And we are trying to convey those guidelines to the community through a lot of events and a lot of tools and ways. We have arbitration forms and notes are and will be made public. So please follow us on our website and our fan page on Facebook, on our YouTube channel, with so many information and instruction from the IAC that we have prepared. And we hope that you would see there are so many new developments of the IAC in the near future. So thank you so much.
Thank you, Hang. I know that it's quite late now. It's 4:29 p.m. Vietnamese time, but would appreciate if the speaker can stay longer to address a few questions from the audience. There's a few questions. The first question is it possible to find via simple email, or how do we secure data secrecy and individual privacy? You know that during the pandemic, it's difficult to travel. So the question is, can they find a notice of arbitration through the email? That is the first question. I think it's to address to own the arbitration institution. The second question is, could you share some tips on choosing arbitrator for both KCAB and VIC? Practical and useful information for choosing an arbitrator other than he or her official profile is generally unavailable. As you know, that arbitration is good as an arbitrator. So that is the most important for the party to choose the right one. I know that for IEC, they don't maintain a list of arbitrators. And for both SIC and VIC, the party can appoint someone outside of the panel of arbitrator. But I don't know the same in KCB or not. So the question to KCB is that can the party pick someone outside of the panel of the arbitrator of the KCB? I also have some few other questions to all of you. First, for the KCB, how important Vietnam market or Vietnamese user to the KCB International? Because I heard Mr. Minh said that for SIC, Vietnamese users rank number 5 or 6, something like that. The second question is, can Vietnamese lawyer appear before KCB, or do they need to appoint or work together with a Korean lawyer? That is 2 questions for KCB. For the ICC, when I sit as a court member of the ICC court from 2017 until 2020, I heard a few complaints about the lack of the cooperation between the party during the process of drafting the TOR, term of reference. So based on your experience, nearly 10 years to work at the ICC court, do you know the same thing happened for the case with the less developed jurisdiction, the same like Vietnam? And the other question is that almost all of you mentioned about the case management conference, CMC. So should the party reach a compromise in the CMC, or they do not need, or they should not compromise anything? Because our culture is a litigation culture that to fight with the opponent by any cost. So it's quite difficult for the tribunal to persuade the party to sit down, negotiate at the CMC. That's why I raised that question. For SIC, Mr. Minh, based on your own experience, what is the legal consequence for a party failure to comply with the tribunal procedural order or direction? Do you know any legal consequence? And for VIC, you have a specific question, I think from a Japanese client. I can read it now. Question for VIC. Number of Japanese invested enterprise in Vietnam that have been choosing VIC. Which reason caused the delay of a dispute at VIC? Are there any specific statistics? Is it based on the value of the dispute? If a user who already knows the value of the dispute, will they be able to estimate the amount of time it will take to resolve the dispute? How is the procedure of expedited procedure in VIC? And how the expedited procedure will shorten the average time for dispute resolution? Any note for arbitration clause? In addition to arbitration fee, what other costs may include when choosing to settle a dispute at VIC? Well, Hang, I think you can write an email to reply this audience. But if you can kindly give a general answer and short, it will be great. So for KCAB first, Mr. Kim and Mr. Lim, who want to speak first?
I'll give a very, very quick answer, and then Ms. Lim could correct or clarify anything. In terms of the filing, you could file by email, but the hard copies will be necessary. You do need to actually send us the hard copies to file on that. On the arbitrary selection, outside of the panel members that we manage here at KCAB, yes, you could actually select from anyone that you feel that could actually represent, basically represent your party. On the question of whether Vietnam is important, for the KCAB International, very much. We do have a number of cases involving Vietnamese parties. They're quite active. They're very active partners with Korea on a national scale. And can Vietnamese attorney appear with Korean counsel? But the short answer would be yes, and I'm sure Ms. Lim could actually clarify on her experience in appearing before the tribunal with co-counsel, whether that's from Korea or from outside of Korea.
Right, I agree entirely, and given the time constraints, I won't add anything more to that. I agree totally.
Thank you both. And Corinne?
Oh, Corinne, concerning the introduction by electronic facilities before the ICC, no problem with that. Concerning your remark on the lack of cooperation between the parties during the terms of reference phase, I don't know very much what they mean by that, because usually it's an open dialogue between the arbitrators and the parties. But if one party refuses to participate, well, as I told you, the arbitrators must move ahead, making sure that the defaulting party has been duly informed about the different phase of the process. And the importance of the case management and the compromise at this stage, once again, for me, the arbitrators is not here to invite the parties to make compromise or whatever. They are here to handle the case and to get the award. But depending on the culture of the arbitrators, I can see sometimes that the arbitral tribunal offers the possibility to assist the parties if they wish and if they want to do it. These are my comments.
Thank you. Minh?
About the mode of service, I think the answer is very similar to the other institutions. Yeah, you can send by email, but it's better to get a hard copy to be sent after the email, especially if you are dealing with a Vietnamese respondent. The second question is about a failure to follow the direction of the tribunal. Then I think I would say that the consequence depends on what kind of directions we are talking about. If it is about the direction to how to present your case, or maybe it's about setting out the time limit to make submissions, then actually failure to follow that may be may give you a very dire consequence, like you may actually lose the right to file the submissions, or maybe you can only ask for a very short extension of time, given that you have a credible reasons. Or maybe in certain cases, if it's about the direction to produce a document and you do not produce a document, then the other party may ask for adverse inference. And the most common consequence can be that, the consequence of cost. You can be seen as playing dilatory tactics, and in the end, you may be allocated a higher share, higher amount of cost, even if you win in some part of the claims. Yeah.
Thank you, Minh. Hang.
So I just respond to my specific question, right? Yeah, okay. So about the delay of the dispute, there's many reasons. First of all, we have to say about service of notice. So please be, as Mr. Minh have just mentioned, investigate the case carefully. Please provide the viable contacting address for BIAC, so we can do this service of notice in a very quick manner. And the other thing is about the other hardship, for example, like the social distancing by the COVID-19. And so sometimes somehow it's very hard to push up the case over that time. But other than that, there's no other ways for VIAC to consider it is reasonable for a case to be delayed. So for anything, you can be ensured that we do have the statistic on the average duration of an arbitration proceeding in VIAC that you can find in our statistic and annual report. But still, you have to bear in mind that the arbitration proceeding is still the proceeding by the parties. The parties are the one who tailor the proceeding. So it really depends on the parties, partly depend on the parties. And the tribunal will, of course, have the jurisdiction to decide the timetable, but the tribunal do respect the parties' agreement on that. And about the value in dispute and the time and the length of arbitration proceeding, I myself do not see any direct links between the value in dispute and the length of the arbitration proceeding, as you mentioned about the parties and the tribunals are the one who try to tailor the proceeding for the specific case. So but still, the value, if a dispute with a huge value in dispute, it mostly arise from complex transaction, as you can see from JV, from M&A, EPC contract, etc. So of course it's really complex, and the time in order to resolve a complex dispute might be longer than for others less complex disputes, such as from the sale of goods, fields, or from just leasing contracts. But still, again, there's no link. We do not see any kind of patterns like with this range of value in dispute. There's an average length. We do not see that patterns. About the cost of arbitration, as I did mention in my presentation, that there's no other cost for arbitration, except from what being published on our website. And as you could see, that Article 33 of our rules on arbitration, we do have other arising expenses for traveling, accommodation, or other expenses for arbitrators. I mean, your arbitrators. So please bear in mind the arising, expenses that might be incurred if when you choose, when you select your arbitrators, in order to foresee about those expense. And of course, other expense for inspection, for valuation of assets, and seeking expert opinion. It really specifically depends on the case, on the development of the case. So basically, no other costs. I mean, no under-table costs, no other extra costs from VIAC. That is what we can ensure.
Thank you, Han, for your confirmation. Now it's 4:43, so I cannot keep you staying longer. Both the speaker and the audience. On behalf of the Area Vietnam Chamber and all the audience, I would like to thank all the distinguished speaker today. And we will upload, with your consent, we will upload all the slides in the website of Area Vietnam Chamber, and the audience can easily download it and contact directly with the speaker if they have any other question. As Mr. Hang, Ms. Hang stressed many times that please feel free to contact with the institution if you have any query or any doubt about something you are unclear. We are closing our webinar today here. And I would like to inform you that the next webinar on Friday next week in the afternoon is about the ad hoc arbitration in maritime and insurance sector, with the participation of Mr. David Stewart, the president of the NMAA, London Maritime Arbitration Association. He will speak specifically about the ad hoc arbitration, especially in the maritime and insurance sector, and about how to work as a full-time professional arbitrator. So we would like to invite all the audience today to join our webinar next week. Now I thank all the speakers and thank all the audience for your participation today. Thank you very much, and I hope to see you soon.
Yeah,
so
thank
much.
you. Thank you.
very much.
Goodbye.
Thank you. Bye-bye.
Thank you.
Thank you. Bye.